All right. If you're watching on our live stream, please recognize that you need to click the refresh button, I believe, or hit the watch button again at the end after one segment and another. And the reason for that is because we break our segments up so that they're easier to digest on YouTube and easier for folks to listen to on our listen line. So, okay, let's finish this topic of where we're at here, because this is increasingly important for us to understand. So, the way precedent works and how court systems work and betray the principles of the Republic are real simple. Courts operate on precedent. And so you understand what precedent means. It is the ruling of an earlier court on a case that has similar circumstances. And since that court found this, we can then find that. All right? And here's the problem with precedent. One, no court ever hears a case in what's called de novo. Now, de novo is when a court takes a case and says, we're going to look at this case in its original context with all of its original facts, and we're going to bring it all the way back to constitutionality. Courts don't do that. That's the problem. Courts were intended to implement the or resolve controversies, not implement anything, actually. So let me clarify that. They're allegedly supposed to resolve controversy by utilizing the Constitution and its principles. In other words, the rule of law. And here's where that falters. Courts don't use the Constitution as its backing documentation anymore. In other words, they don't look back at the Constitution and say, constitutionally, this is what should happen and should have happened in this case. Instead, they refer to earlier cases and they say, well, the justices in this case found that it was constitutional, so therefore we're going to find that it's constitutional. You can smell the problem right away. Here's what happens. You remember the game telephone. You say something to some person, you whisper it in their ear. This is a party game. They turn around and whisper it to the next person. They turn around and whisper it to the next person, and so on and so forth. 10, 12, 15 people away. The story that was originally whispered is nothing at all like the story that comes out of the last person in line. And the reason is because every person has a different take on what they just heard. And courts who are ruling on a controversy are ruling on a controversy based on precedent that was on a case that was, for all intents and purposes, completely unrelated to the case that they have at bar, which is what that's called, in front of them. And so here's what happens. They'll use precedent from a civil case and a criminal case, saying, well, the Supreme Court ruled in Smith versus the New York Tribune that this is the case. And so therefore, when it comes to free speech on your client, which is a criminal case, we're going to ride on that. And we're going to stand on the shoulders of that previous case. That, folks, is not justice. And that was not the intention of our Constitution, nor of our founders. You see, our Constitution says there's really only one court. That's the Supreme Court. And that court has the right to create lower courts to hear cases of lesser importance than those regarding complete constitutionality. But that does not give courts the right to take cases and utilize non-constitutional decision-making processes in the outcomes. In other words, they've been delegated to accept, or delegated, I should say, to hear cases of lower importance than those of national significance, but it doesn't mean that they're relieved of the obligation to follow the principal concepts of jurisprudence. And that jurisprudence says that every case is related back to the Constitution. Every one. So, what we have here is a case where they're going to take these two cases, or at least one of these two cases, and what you're going to find is that they're going to find on the side of the government. Why? Because courts, by their very nature, owe their allegiance not to you and no longer to justice. They have become politicized, and they take political football cases and they hear them out. And they resolve them always in a way that advances the position or the ideology of their benefactors. And who are their benefactors? Well, government itself, especially the Supreme Court. Why is that? Well, first of all, they owe their financial benefit or their financial situation to the government. A Supreme Court justice is appointed by the president. He's then approved by the Senate, but he's appointed by a president. And here's the problem. He or she is appointed for life. There is no exit strategy. The only exit strategy is to go out in a box on a plank. And so the Supreme Court justices sit in play for all intents and purposes for life. And if they're young, they have a long, long time to meddle in the Constitution. So when we talk about these cases, we have to understand that these judges are going to rule in favor of their benefactor or their masters, not in favor of the Constitution. And to do that, they're going to stand on case after case after case after case of precedent. I'm going to prove that to you right now. There's an article which I also posted up, which is on RT.com. And there's a couple of important phrases I want to read you out of the story. In recent weeks, 2 cert petitions, and when you apply to the Supreme Court, it's called a writ of certiorari. Now, that means that they are asking the court to please hear this case. The court says, yes, we will, or no, we won't. They were filed seeking a review of whether the Fourth Amendment covers police searches of cell phone records upon an arrest. That's the one we just talked about. For mobile phone and GPS tracking to license plate reading and domestic surveillance drones, not to mention recent revelations of widespread abuse of surveillance capabilities by the NSA, these cases and many others highlight major questions that remain unanswered regarding how privacy rights of Americans can coexist with the use of rapidly evolving technology. For the record, you heard Rand Paul come out the other day and state that the Supreme Court should be hearing these cases about NSA surveillance. And while I want that, I also fear it because, again, these courts don't actually operate with the true purpose and spirit and intent of jurisprudence. They're operating as a rubber stamping mechanism for government tyranny at this point. And we know that for a fact. When you got a guy like Justice Roberts, Chief Justice Roberts, who approves of Obamacare despite every argument to the contrary and the best wishes of the American people in vast numbers, you got to recognize that something's desperately wrong with the allegiances and the alliances that the court has developed and who they owe those allegiances to. There was a petition filed. Well, let me go back. State and federal law enforcement agencies have wasted no time seizing on gaps and omissions, that's loopholes, in established legal precedent to justify vast routine surveillance of the American public which tests Fourth Amendment rights. This goes back to my earlier point. You see, when the courts rule, they make a ruling that everyone else then turns around and says, aha, if I say I interpret it this way, my agency can do that. And that's exactly how they're abusing us every single day. They are leaning upon Supreme Court rulings and previous precedents from other cases to say, this is how and why we justify the extra constitutional actions we're taking. And that, ladies and gentlemen, is where the rub comes in. On July 30th, a petition was filed in Riley versus California, challenging a previous ruling in a California appellate court that affirmed the petitioner's conviction, which stemmed in part from a questionable search of his smartphone in 2009 following a traffic stop for an expired license plate. This is the second case now. And late last week, the U.S. Department of Justice filed a petition in United States versus Worry, asking for a review of a First Circuit Court of Appeals ruling that police needed a warrant to access a suspect's phone records. Regarding Worry, the government contends his cell phone is no different than any other item on a suspect at the time of his arrest. The search on Worry occurred in 2007. That was the first case we talked about. On the surface, the two cases have much in common. But in Riley, the phone in question is a smartphone, a Samsung M800 model. In Worry, the cell phone was a flip phone incapable of maintaining the breadth of information like internet searches, email, photos, and other media that a smartphone can store. So here's what we're going to do. Here's what you're going to find. They're going to take Worry. This is my prediction, but they're not going to take Riley. And here's why. Worry is a safe case for them. It's safe for them to take that and say, Worry, they had a right to search Worry. Then they're going to go back and the case in Riley is going to say, well, see, the Supreme Court said that it could be done in Worry. Get it? That's how they do it. Ladies and gentlemen, that was not what this system was intended to do. As of May, Pew Research finds that 91% of Americans own cell phones, and fully 61% of those are smartphones. My prediction is simply this. They're not going to take Riley, the smartphone case. They're going to take Worry. And they're going to take Worry because they're going to use Worry to show that Riley was legitimate. That and many, 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 many other cases that are going to come along before they finally are forced to take Riley or another one like it. Actually, they'll never hear Riley. If they deny it, then there's almost no chance that the Supreme Court will ever again be presented with the Riley case. Once they refuse cert, that's it. You don't have any other choices. You're done. You've reached the limit of appeals. You spend whatever time you spend in jail, and that's it. Okay? That's how it works. So, now there's been other cases about GPS and how the courts have dealt with GPS. Last week, the Justice Department appeared before a federal court defending its right to shield legal memos that provide guidance to federal prosecutors and investigators on how to use GPS devices and other surveillance technology from the public. Here, this is really interesting stuff. In a sense, the memos were released upon a Freedom of Information Act request by the ACLU, although their contents were heavily redacted. So here's what you need to understand. The Justice Department is now going before a federal court seeking the court to rubber stamp their use of GPS and smartphones and such, and how to use GPS devices and other surveillance technologies against you. Right? They're not defending something that's on their phone. They're seeking the court's permission to use that information against you. And the ACLU filed and then they keep the decision secret. That's the problem. You see, the decision, once it's made, is maybe public, but then the policy that they create behind that decision, they keep a secret. And when the ACLU said, okay, so if you're going to take that court case and you're going to create policy as a result of that case, then the public has a right to know what that policy is. And they have a right to know how you're going to implement the new policy you've created based on a court case that was resolved by the courts. The Justice Department says, no, you don't. So not only are they using the courts as a weapon, they're also using the courts as a shield. And that is never the intent, the function, the foundation, the principles, or the tenets of a free society. Governments cannot keep their policies and application of law secret. I mean, our founders told us very clearly that when laws are not clear enough to be understood by the average person, they are not law at all. And here it's not even a question of understanding what the law is. They're not telling us how they're going to apply that law. We don't know. And they keep it a secret. The memos that were obtained by the ACLU, and there's links to them in the story, were legal interpretations of a January 2012 Supreme Court ruling in U.S. versus Jones, in which the court ruled that the use of GPS technology to track a car's movement constitutes a search within the parameters of the Fourth Amendment. In other words, the court found that if you use GPS technology to track a car's movements, it is a search. Upon release of the indecipherable legal memo, the ACLU filed a lawsuit seeking a full, uncensored guideline of what the DOJ and the Department of Justice is going to use or how they're interpreting that. And this harkens back to the NSA surveillance issue, where you have a guy like Clapper who goes before the Senate and the House and says, we're not capturing cell phone conversations. And when questioned further on that, he says, well, it's not the conversation, it's the metadata. Then questioned deeper, we find out that they're not actually, we find out that they are actually capturing it, they're just not listening. In other words, they very, very carefully word their answers so that it's almost impossible to grind the truth out of them. When he was and I can't think of who this was, but I posted it up on our Facebook and our website some time back. When an NSA official was questioned about whether or not they are listening to Americans' phone calls, they said, his answer was, we don't have that authority. He didn't say, and notice the carefully way that they word their answer. We don't have that authority. He didn't answer the question. Are you capturing and storing that? And he said, we don't have that. He said, no, we don't have that authority. So, you see, what he's saying is a double entendre. It's like a double helix of DNA. No, we're not. We don't have the authority for that. But that doesn't mean, no, we're not storing it and saving it for later dissemination. You see, I'm telling you, everything that you hear coming out of the mouths of these administrative officials in whatever capacity they are now, everything is carefully minced, combed through, and clearly regurgitated back to them by legal teams who are verifying that nothing that they say, and they are so careful about parsing their words that nothing can be held. They can't use any of what they say to pin them up to the wall. And that, again, shows evil intent, because what it tells you is that someone is trying to mask the truth. If you said to your 4-year-old, were you in the cookie jar? And he sits there and comes up with a million excuses as to why not. You don't have to be a real intellectual scholar as a parent to recognize he's trying to avoid lying to you. So what he does is he comes up with 1,000 circumventing arguments and stories. He'll come up and start saying, well, you know, Bobby and I the other day were out playing. And you're like, that's not what I asked you. Did you have your hand in the cookie jar? You know, Grandma came by the other day and she called and she said, he wants to avoid lying. So what he does is he constantly throws out, they're just not as intellectually mature as these tyrants in government that are fully skilled and carefully schooled in how to mince words and twist the meanings of what they say. But make no mistake about it, their intent is the same: to misdirect, mislead, and avoid answering the question in a direct fashion that will reveal their true guilt. And that's how you know the guilt exists. If they truly were not doing this, they would say, under no circumstances and in no way, shape, or form are we capturing and storing individuals' phone calls for later review or current review or later dissemination or current dissemination or listening at some later time. See, that would be a very clear and definitive statement that would make it very apparent. But they don't say that, and I'll tell you why they don't. They don't want to be convicted later on of perjury and lying, and furthermore, they don't want to give Congress the opportunity to fully understand the true depth of their role. They're lying, and they know they're lying. And you know they're lying because anytime someone lies, they will always try to move around the question, to answer a different question, or couch it in a way that will mislead you. That's it. You only have to be a student or an observer of human traits to understand exactly how that happens and to see fully how it works. I strongly encourage you to to monitor and review how people act, because it's critically important for you to grasp the idea of what people do when they are trying to betray, right? In other words, when people are trying to mislead or betray, it's up to you to recognize when they're doing that and how they're going about doing it. And again, you don't have to be a psychology master or even a student of psychology to understand how it works and what people do. You can observe your 4-year-old and get the same result. Now multiply that times the people in Congress or wherever that are doing the same exact thing, and you have your answers. So what's important to recognize and understand is that what we see today is a complete and total fabrication and misuse of, one, the legal system and how they take that information and stand on the shoulders and build upon the precedential rulings of previous courts to justify their treasonous actions today. That's the real kicker here. This is an important statement from the ACLU. By the way, I'm generally not a fan of the ACLU, but I want you to recognize that in some cases, and in this particular instance, they are doing great work. And I will applaud them for it. Unlike an ideologue who says, I'm always against everything everybody does, we don't do that. As critical thinkers, we recognize when things have been done that are right, irrespective of what framework it comes from. And I'm telling you right now that the people that are on your side right now are the Democrats, not the Republicans. And that, ladies and gentlemen, is the perfect reason for you to never believe in political parties again. Completely abandon the concept of party, because party will get you killed. And that's the truth. Listen to what this guy has to say. While we agree that executive branch lawyers should be able to freely discuss legal theory, once those opinions become official government policy, the public has an absolute right to know what that policy is. Otherwise, the government is operating under secret law that makes accountability to the people impossible. Boom. That is the heart and the crux of this matter. What you have is cases over and over and over again that the courts take on when they have an opportunity to leave a loophole big enough for law enforcement, Department of Justice, or anybody else who wants to abuse it, including the EPA and so many of the other laws that all these other administrative agencies find that they can drive a truck through the loophole size. See, they don't want a loophole that you can barely get your pinky in. They want loopholes that you can push the state of Texas through. And that's exactly what they do. The courts make these nebulous statements that leave everything wide open to gray. And then the government takes that and runs with it. Proof in point. The National Defense Authorization Act, allowing for the indefinite detention of Americans, is predicated upon what act? A belligerent act. Now, I ask you, what constitutes a belligerent act? There's the gray. There's the gray. Any act can be construed or constructed to be belligerent. Anything. This radio program can be construed to be belligerent. Your refusal to step back from a march when instructed to by a law enforcement official can be construed as belligerent. In fact, I'm going to take it one step further. The new law in New York State that makes it a felony to annoy, that's the word they use, to annoy a police officer is proof positive. That's a belligerent act. Ladies and gentlemen, we're going to take a break. When we come back, we're going to take the Wi-Fi mesh topic tomorrow, and I'm going to spend a lot of time on it because it's an important issue for you to recognize. The next thing we're going to talk about is Greenwald's partner being searched in the airport and what's going on with that. Because, again, what we see is tyranny in the name of government. And it's not just here. It's global. And don't make any mistake about it. They did that at the behest of the United States of America. We're going to take a break. When we come back, please click the start button again on your video stream, and you'll be able to watch that program as well. We'll be back in just a moment. You're listening to America's Voice Now. My name is Michael Evans. We've got 2 more segments to go, and both of them are important. Stick with us. We'll be right back.